Hello, 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 and welcome to Alexasrewm, where we are not law enforcement, we are not medical professionals, we are not lawyers, we are just people who have opinions about all things going on in the true crime community, including what the heck is going on with the Karen Reed case, because y'all, the saga continues, and it was a busy Monday for Team Karen Reed. The defense has filed a motion to dismiss not one, but two counts of the charges that she was indicted with. We are going to go through the entire motion later in this video, as well as the two affidavits that were signed by both Alan Jackson and David Yannetti. But the news doesn't stop there. Of course it doesn't, because why would it? Judge Bev also was a busy bee behind the scenes. She put together an order. It seems like kind of in response to the motion that was filed earlier today. So we're going to get into that one as well, too. She's got some news going on there. And then our friend, the one, the only, the man, the myth, the legend, Trooper Michael Proctor had his hearing today. So we have all the updates. We're going to be going through that. But first, before we get into any of that, I wanted to just say thank you so much for all of your support these last few weeks. I know I started this channel kind of in the middle of, well, not kind of, really in the middle of the Karen Reed case. And I just appreciate every single one of you that has dropped by, left a very kind, respectful comment in the comment section below as well too. It's just been amazing. It's been amazing to learn and to discuss this case. I'm still going through the comments on my last video. So please don't take offense if I haven't replied to you yet. I'm going through every single one of them. Some of you have emailed me as well too. I have a day job, so it's kind of hard balancing the two, but I promise you I will try my best to get back to every single one of you who has reached out to me, and I really appreciate the support. And thank you so much for helping me get to 200 subscribers. It's just absolutely unbelievable to me that this many people want to have these kinds of discussions with somebody who, like I said, I don't have the privilege of having a legal background. I don't have a law enforcement background. I'm not a medical professional. So these are just my thoughts and opinions based on my own life experiences as well too. And I just hope to continue to learn more, and most importantly share these stories, because I think they're really important to share. And the stories don't stop with Karen Reed. We're going to continue covering this case very closely, as more just seems to continue to unravel on a day-to-day basis. But we will also be covering other trials, other cases. I know there's been a lot of updates in the Sandra Birchmore case as well too. There's a loose connection, or again, I don't want to say a loose connection, but there is a somewhat of a connection between that case and this case, in the sense of there are some similar people who were involved. As I'm learning more and more about that case, I will share that. But right now, we are full Karen Reed. And if there are any other cases you want me to look at, please feel free to email me, email me at alexasroommate@gmail.com. That's 1M. So alexasroommate1m@gmail.com. And again, thank you guys so much. If you enjoyed this video today, hit the subscribe button, hit the notification bell so you never miss another update about this case from me, and hit the like button, because that helps this story reach more and more people. And again, it's important that we continue to put public pressure on the DA's office in the state of Massachusetts. All right, so let's dive into today's news. Also, so before I get into this, we're going to start first with the motion that was filed, then we'll get into the affidavits. I might also pull a couple of clips from when Bev was reading the jury instructions, just because at the time, I couldn't, one, find the clip for whatever reason. I think some of the trial coverage that was being done, especially by Court TV, they were um, filmed in like separate video clips. So at the time, I just was like, okay, cool. And I was watching other coverage, and I'm like, all right, it's probably fine. But this is where a lot of the controversy lies, actually, and just the misunderstanding of the verdict slip form that Alan Jackson and David Yannetti had argued with Judge Bev over. And I posted this in one of my past videos as well too. I can link that in the description below. But I'm going to pull that clip up as well too, what the argument was about and how it's related to this motion directly. Full disclaimer, I'm still getting over being sick. I don't know what happened. Maybe I partied too hardy on Thursday, 4th of July. I don't know. So if my nose starts going like in and out and I sound like Michael Morrissey, just ignore that. And feel free to turn my sound off and turn on closed captioning. I won't be offended by any means. All right, so let's get into what NBC Boston has to say. So, yeah, this was swirling around Twitter pretty much from the moment I woke up this morning. But Karen Reed is moving to dismiss 2 of the 3 charges against her, including murder, including the second-degree murder charge, with her attorney saying they've heard the jury had unanimously concluded she was not guilty of either charge. So remember, there were a lot of rumors pretty much from day one of verdict watch, or not day one rather, but when the first time the jury uh, came to Judge Bev with the note saying that they were deadlocked, they couldn't reach a verdict. 3 of the jurors had come forward since the trial was declared a mistrial, um, to the defense team. So just to give you a little bit of a precursor into this, but let's continue reading on, then we'll get to the motion itself. Unanimously concluded she was not guilty of either charge. So I don't know, again, if you guys aren't on the Twitter scene, I'm more of a voyeur, just kind of looking in, seeing what the buzz is going around. It helps me access information faster. But there was a big rumor going around by some reporters, namely one with a towel for his icon, which is highly offensive to me because I love South Park and Tally is one of my favorite characters. So if you know who I'm talking about, that is the reporter who was swirling around that there was a 10-2 split in the jury pool of guilty to not guilty. Um, but that has been since debunked, at least according to this motion. Reed filed the motion to dismiss in Norfolk Superior Court on Monday, today, a week after a mistrial was declared in the murder case against her, leaving unresolved a case that's attracted attention, blah, 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 pretty much nationally, now globally. Reed is accused of killing her boyfriend, Boston police officer John O'Keefe, during a snowstorm outside a Canton home, 34 Fairview, in January 2022, though her team has maintained she was framed. Reed was charged with murder in the second degree again. So we're going to go over the jury slip, the original one that Jackson Yannetti had an issue with, rightfully so, because it was kind of confusing. Manslaughter while operating a motor vehicle under the influence of liquor and leaving a scene of personal injury and death. She pleaded not guilty. When she declared the mistrial, so Judge Bev didn't provide any insight into how the jury voted, so she didn't poll them. Now, there's been a lot of, specifically like with lawyers too, giving different commentary on this. Now, I was curious, like, what the actual law is behind whether or not it's up to the judge to poll them, if it's something they're obligated to do. So I looked this up on the here it is. On the Massachusetts Gov website, Rules of Criminal Procedure. So if you go down to section D, when a verdict is returned and before the verdict is recorded, the jury may be polled in the discretion of the judge. If after the poll there is not a unanimous concurrence, the jury may be directed to retire for further deliberations or may be discharged, which essentially she did, except without the poll. So from my understanding, and again, I'm not a lawyer, if there's any lawyers in the comment section, please, chime in, especially if you're familiar with Massachusetts law. But the way that I'm understanding it is ultimately, I mean, in this case, there was no verdict, essentially, right? But it seems like it's up to the judge's discretion whether or not she wants to poll the jury at the end and let the lawyers know what the exact jury split is. Why this is relevant? Well, we're going to get into that when we dig into the motion. So I just wanted to give you some of that context. And I can link all this stuff to you in my comment section if you're curious and want to read more into Massachusetts state law, because I had no idea how any of this stuff worked. So just wanted to share what I'm learning with you because that's what we're all about here, right? All right, cool. So now we're going to go back into this article by Boston 10. In Monday's filing, her lawyers wrote that they began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no certain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty. I'm going to read that again. In Monday's filing, her lawyers wrote that they began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. So, what does that mean? That means that all of the jurors believed and agreed that Karen Reed did not intentionally kill John O'Keefe right off the gate. And it sounds based on, again, how I'm interpreting the language in the motion. Now, again, no jurors have been called to testify. This is why the defense has to file a motion so that they can dig in and get more evidence, so they can put together an additional hearing, so that they can potentially call these jurors to testify under oath that, yes, in fact, we agreed unanimously that she was not guilty of second-degree murder. Cool. So if that's the case, my understanding, she can't get retried with that charge again because that would be double jeopardy. So, and that was the biggest thing. I mean, again, we're not going to drag Paul O'Keefe. We already made a couple videos about him interviewing different news outlets. There's going to be a lot of people playing defense now, no pun intended, from the prosecution side and probably the DA's office, right? I'm sure we're going to hear more and more from them. And they made a comment too. They made a comment too today, which is fascinating to me that they would put out a statement like that. So we will get to that. But unanimously, they all agreed that she did not intentionally murder John O'Keefe. So, what is the second charge? What is the thing that they were hung up on? We will get to that. And what is the other charge that they dismissed her on? That was the big one, though. That was what we wasted all that time talking about, calling up witnesses about Aruba, and Higgins, and the text thread between her and Higgins, trying to prove some kind of weird motive, and reading all those text messages between her and John O'Keefe and the voicemails. That was all to prove intent. But the jury wasn't buying it. Cool. The document was filed by 2 lawyers Reed used throughout the trial, Alan Jackson, David Yannetti, as well as new lawyer Martin Weinberg. So he's the new he's the new player on the team. He's, from my understanding, my limited research on him, he's been in the game for a long time as a criminal defense attorney. Actually, I was watching Lawyer his stream earlier, reading through this, and his father, Peter Trigus's father, actually, I think, tried a case with him, which is really fascinating. So definitely check out that stream where they break the entire motion down as well, too, if you want a legal perspective. But I thought that was fascinating. So he's well known as a Boston criminal defense lawyer. In separate documents filed Monday, Jackson and Yannetti detail how they were informed about the jury's discussion. Jackson said one juror reached out to him directly on Tuesday. So a day after it was declared a mistrial, because those people were going on YouTube and Googling the F out of this case. I know I would. I'm probably like, holy crap, this is what they're saying. And I've seen a lot of people on Twitter being like, thanks to to all those people who were rumor spreading around the rumor mill that it was a 10-12 split. So in that respect, yeah, because if they weren't, then maybe these people wouldn't have felt comfortable enough to come forward. I mean, I hope they would, because they feel like that there's an injustice being done to Karen, because it's just not simply true. And I hope they get to testify to that. I hope they do. Jackson said one juror reached out to him directly on Tuesday after seeing inaccurate reports exactly about the split among the jurors related to the mistrial, right? And these were jurors who took their gig seriously, which is good. I think we can all agree that these jurors really like carefully considered everything for both sides. So the fact that three people came forward and said, "Hey, this isn't right," they're not obligated to do anything, so I think that's really amazing and commendable of them to do so, if this is the case. But, I mean, why would they swear affidavits, Jackson and Yannetti, swear on their essentially their careers and lie about something if it weren't true, or if they didn't believe it to be true? While Yannetti said he heard from two intermediaries who'd heard from jurors. So essentially, third party folks who were close to or knew had spoken to two other jurors. A representative for the Norfolk District Attorney's Office said Monday they were reviewing the motion and anticipated filing a response and looked forward. So, this is the garbage statement I'm talking about. Anticipated filing a response and look forward to picking a new trial date. Okay. They're looking forward to picking. I mean, what are you going to charge her with? If this is true, and if they swear in an affidavit, or they swear through testimony, excuse me, that this is true, what are you going to charge her with? You're going to charge her with the second charge? But that's gonna be to a whole new jury, and that the entire theory that the Commonwealth was going with, they're gonna have to rearrange everything. I mean, it'll definitely cut down the number of witnesses that they're gonna call. They won't have to call any of the Aruba people, and if they did, like, I mean, why would that was the whole point, was to prove some sort of intent. So, I mean, in that regard, the trial will probably be significantly less, like, in terms of number of weeks and time. Hearing has already been scheduled for July 22 to set the date. I mean, again, I'm not a lawyer, but according to lawyers who have commented on this case, that hearing is less for scheduling a date. Like, yes, I guess if the Commonwealth feels like they're prepared to set a date, they will, but it's more of a status update. So we'll see what happens. Alan Jackson's not going to be in town, neither is Eliza Little. So I imagine now that they brought on Mr. Weinberg, that he's probably going to show face during that hearing as well. And are we going to have a hearing before then? I mean, if the DA's office is going to file a response shortly, I wonder if they're gonna try and run out the clock and wait until after the July 22 hearing, or try and get it done before. I mean, I don't see the point in waiting on this, because I feel like that does affect the July 22 hearing. So, who knows what's gonna happen? Part of me feels like, with the scheduling conflicts that were being discussed during verdict day, mistrial day, when they were trying to get their ducks in a row and figure out a date to meet. Um, Maybe Weinberg is there kind of as a standby to be like, hey, like, if we can't do this thing, like, can you step in and fill in? Because I know David Yannetti had some conflicts as well too. So I wonder if that's why, or if they just wanted another pair of eyes to help them through this. I mean, she's got a dynamo team without a doubt. So this is going to be interesting, 100%. So I wanted to lead things off with that article, give you some context. Next, I want to get into the verdict slip because, again, having all this context is really, really important, especially if you're just kind of stumbling in or you're piecing, again, piecemealing. There's so much information, so much that has been going on in this case, and even post trial, it's hard to keep up with. So sometimes we get to backtrack a little bit. I'm gonna have timestamps so you can skip ahead as you need to. I'm not gonna take offense, but I think it's important to refresh our memories because this is all related to this motion directly. So this is the clip between Alan Jackson, Karen Reed's lawyer, and Judge Cannoni talking about the original jury slip because that's going to come up. That's going to come up in either the motion or the affidavit. I believe it's in the motion.
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agree that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
Can I ask you a question then? I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you would mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court.
So that's the second charge. That's the second one. The first charge has its own slip. That's the murder 2. But the involuntary manslaughter, so meaning that she didn't intend on hitting him. And we're gonna pull up the slip after this clip. Just so actually, I'll bring it up now because it's gonna make more sense for y'all. I know I have it. Yep. Okay. Cool. Right here. Sorry, I have like a million tabs. Okay, so this is the original slip. Let me see if I can zoom in. Okay, that's as far as we're getting. So this is the second slip. This is what Alan Jackson is talking about. So there's the not guilty tick up here, which again, like when you're looking at it, does it make, is it easy to navigate? Like, okay, for me, I interpret it as, and if I could potentially be a juror, you could be potentially a juror in the jury box, right? If I think not guilty, that for me means, okay, that's not guilty of everything. That's just canceling out everything. But the way the judge explains it is, well, if they don't think she's guilty of manslaughter while operating a motor vehicle, then they just won't tick the box. But I mean, it's not like there's any written instructions up here indicating that. Like, hey, if you don't think she's guilty of this specific thing, then don't tick this box. And making sure and confirming, at least verbally, that they understand. I mean, I feel like that would be helpful. But apparently, this is how the slips are in Massachusetts, according to Judge Cannoni. So this is what Alan Jackson is talking about. There's no way for them to say, okay, she's not guilty of this, and adding a tick box here. She's not guilty of this. She's not guilty of this. Guilty of lesser included offense. Involuntary, again, not guilty of this. So it's very unclear as to what ticking not guilty actually attributes to. You know, and this is where some of the confusion came for some of the jurors, as Alan Jackson suspected and David Yannetti suspected. Because, again, these aren't lawyers. And there are people like me and you. We look at this thing, we're exhausted, it's hot, we want to go home, it's the summer, we want to hang out with our friends and family. We don't want to be like sitting in a hot, sweaty room with all these people screaming about whether or not we think this woman is innocent or guilty. We want to go home to our family and friends. And, looking at it and being just overly exhausted too, it's like there's no way to clearly understand, yeah, okay, like if I tick not guilty, in my perspective, this is how I see it. If I tick not guilty, that means not guilty of everything. But if I don't tick not guilty, then like what do? Do I fill out anything? And I don't know if these questions were asked in the jury room. So now we're gonna go back to the clip because again, this is the exact point that Alan Jackson is gonna bring up. Is that how do they know? How do they know which box to tick or how to say we don't think she's guilty of this thing?
They decide that she's not guilty of involuntary manslaughter on that verdict.
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the.
But it's like that. I just hate her response there. It's like so snarky. It's like they don't do that, then do that. Like it's so obvious. And it's just so clear that like she's just expressing her dislike for Alan Jackson. She's like, I just declared a mistrial. I'm so over this. Like, I don't want to see your face. I don't want to deal with you anymore. And it's like, girl, like this is not easy for people to understand. Again, you can't, when you assume, you make an ass out of you and me. And you can't assume that every single person on that jury pool understands or interprets information the same way as you do. That's why we have a jury pool, to get all different kinds of opinions, to interpret the evidence that's coming in, to get a totally unbiased mix of people. That's why we have that. That's why we have this process in the US. I mean, so yeah, not everybody's gonna look at this form and have the same understanding of it, especially like if you're getting people, are these all people who are born and raised in Massachusetts? I mean, maybe they are. Maybe they've been on jury pools in the past. I don't know. I don't know how that works. I've never been on a jury before. I don't know what that process looks like, but again, these are people from all different backgrounds, all different education levels. Some people might not. I can bet you there were people zoning out during your jury instruction read. So maybe they don't fully understand. Maybe they think, oh, I don't need to really pay attention. I just probably tick a box or something. I don't know. Somebody will explain it to me again later. So I think it's very reasonable for the defense to say, yeah, like this isn't there's no clear instruction saying if you don't think she's guilty of X, Y, and Z, then the instruction is do not tick the box. Do not tick anything. You can turn in a blank form. But if you give people only one option, guess what? They're gonna take that. I mean, that's like the number one rule in marketing. And I always tell my clients this too, is you don't want too many options to give too many calls to action, too many options for people to buy too many different things. Because if you give too many things for them to decide over, that's going to create indecision. And people aren't going to know what to do, and they're not going to do anything at all, and they're going to be confused. And it's going to cause frustration. So, yeah, I can definitely understand it from at least a lay person's perspective. Let me know what you guys think in the comment section, if you agree, or if you think the verdict slip is clear. Again, let me just pull that up one more time so you can see. So again, this is the original slip, right? This is the second slip. This isn't the murder 2 slip. That had a different slip. It's just this one box of not guilty. In the above entitled case, we, the jury, say that the defendant is not guilty. Like, not guilty of what? Again, And the way that he frames it is it seems like you're guiding them towards making a decision towards guilty of a lesser included. That's the way it looks like. Because there is no option for not, it's only up here. So, and I have to agree, it's confusing. So let's finish up with that clip. We'll get into the motion. Just back it up a little bit.
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
She just makes it sound like it's so obvious, and it's like, no, it's not that obvious, Bev.
It's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't run.
Have you
My
had no
favorite.
lesser included?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the
Okay.
I mean, not for nothing, like Bev, like even if he did, like, do you think he's honestly gonna go against his team and say, yeah, no, you're right, of course, judge, of course? Like, he's not Lally, he's not kissing your butt. Come on now.
I disagree with you. All
And
right.
I don't see the
Excuse me. This is funny, Ms. Reed.
Yeah.
All right, we're done.
And then
I'm Millie, a content.
she throws a little temper tantrum because Karen Reed apparently smirks or laughs or something. And for me, I mean, a lot of people on the opposition are like, oh my God, Karen Reed, like you should be expressing more remorse and blah, blah, blah. And it's like, no, she's probably at a point where she's like, of course, what else is not going to go my way? That's the way I kind of interpreted that reaction. So now that we have that context, let's go into the motion. And again, if there are any lawyer friends in the comment section, let me know. Let me know what your interpretation, or if there's anything, if you also want to hop on to. I know a couple of you have expressed that you would love to see some guests come on. I would love to bring on people. I also want to make sure that I can pay to bring those people on, because I believe time is extremely valuable, and I want to make sure that we're able to support everybody in the best possible way. So as we continue to grow this channel and we continue to grow our resources, I will bring on guests. But if there's anybody who's interested and has been following the case, you have a lawyer, you have you're a lawyer, or you have some kind of law enforcement background or anything like that, let me know. You can email me again at Alexasrewm. That's with 1M at gmail.com. Link in my description. And I would love to bring you on. Absolutely. So let's dive into this motion. So I wonder if I can get it more centered, because this is like super awkward. I guess not. Okay. So now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. So that was a lot. Okay, so let's just bring up those charges one more time. So, court detailing Reed's motion to dismiss says that she is moving to dismiss, again, count 1, which is the second-degree murder charge that they all voted unanimously 12-0, according to the affidavits, and count 3, which is leaving the scene of personal injury and death. So those are the 2 counts that the defense is looking to dismiss. So now let's get back into the motion here. The ancient right to a jury trial is no mere procedural, sorry, my nose again, formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among the reasons colonists cited in the Declaration of Independence, how timely, right, guys? For their break with Great Britain was the fact Parliament and the Crown had deprived, in many cases, of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, remember, Lally likes to quote John Adams. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Because again, like every time she goes, the more that her defense is working for her, the more money she's spending. They're on her payroll, so I can't even imagine how much money she's spent on this trial. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited. So now we're going into the crux of it. Now that they've explained, okay, these are her rights according to the Constitution, according to Declaration of Independence, right? Now that we understand that, what exactly are we filing this motion for? Undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree, which she was facing up to life for. Life with parole, but up to life. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges because remember, they got that hearing coming up on July 22nd. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue. So again, they want to present in front of the judge after the motion is reviewed, right? To have a chance to gather more evidence, call the jurors to testify under oath that this in fact was their decision. Be held on the issue, and that the court authorized defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they would not reach a verdict on the 3rd charge alone. background. On June 9th, 2022, Miss Reed was charged via 3 separate indictments with murder in violation of vehicular manslaughter in violation of, and leaving the scene of personal. So again, these are the 3 charges. And leaving the scene of personal injury or death violation or death in violation. A jury trial began on April 16th, 2024. On June 25, 2024, the jury began deliberations. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to the counsel for review. Rather, the court indicated that the jury was at an impasse. So we can pull up that clip, but I did post a video on this, so I can link to that as well too. And that's all she said. The jury's at an impasse. Let's call him in. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing an opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. So again, this was when she read the note that was very eloquently written, the starkly divided. That was the note that they are referring to here. So not that, remember they had a couple of notes. First they were asking for the cert report. Then they said, hey, we're deadlocked. And she was like, hey, go back in there. And then they came back again. They were like, hey, we're still deadlocked. And she read the Tui Rodriguez charge, then instruction rather. And then after I think a few hours on that Monday, it wasn't very long, they came back and they're like, yeah, we're still deadlocked. But of what? Of what? What were they deadlocked on? She did not disclose that. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or 3 of all the charges in the indictment. So just like I said, she didn't say we just all assumed that the jury was deadlocked on everything. That they couldn't agree on any of the charges, which again, she was indicted on 3. So what was, again, this was all the rumors that have been going around for the last week, what the jury split was, and would we ever find out what the jury split was? The following day, on July 2nd, Attorney Jackson, so this is a day after, Alan Jackson gets contacted by a juror in this matter, and they're not doxing anybody. Juror A, who stated that she/he wished to inform him of the true results of the jury's deliberations because they saw all the bull crap that was going around the internet. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic, that count 1, second-degree murder was off the table and that all 12 jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, so leaving the scene with injury and death. So that only leaves that count 2. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by 2 different individuals, hereinafter Informant B and Informant C. So these are not the jurors themselves that contacted David Yannetti. These are people who were in communication or had heard from a juror who participated in the deliberation process. And they informed David Yannetti and included screenshots, I believe, as well. Excuse me. Who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. David R. Yannetti affidavit. So that it's from his affidavit, which we will go over in a second. Informant B sent Attorney Yannetti a screenshot he or she had received from someone. So this would be intermediary B. So there's the informant, then there's like a middleman, and then there's the juror. So again, it's kind of like a chain of telephone of text messages that intermediary B had had received from Juror B. In that screenshot, Juror B texted the following to intermediary B. It was not guilty on second degree, and split in half for the second charge. So it pretty much, again, it's like if I told my wife and then my wife told her friend, and her friend was the one who contacted David Yannetti. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. That's what they said. Allegedly. To intermediary B. No one thought she hit him on purpose or even thought she hit him on purpose. So they said, it sounds like they said the same thing twice. I mean, reading that back, no one thought she hit him on purpose or even thought she hit him on purpose. I don't know if that was like they said the same thing twice, or like they're saying they didn't think that she thought she hit him on purpose. I don't know. Informant C had been in contact with another individual. So again, there's another third party person, intermediary C. Gosh, I can't get that word out. Who is a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. So again, these are screenshots, I guess, in like that Zoom chat. No consideration for murder 2. Manslaughter started pulling, and this is a crap too I want to call out, because I've seen people like frickin' Wendy Murphy, who should know better, as a former prosecutor, who should know better than to make up lies, because it says clearly in this affidavit, in this motion, that it wasn't 10 to 8 or 8 to 10 for manslaughter. I literally saw a tweet today saying that it was 8 to 10. It was not 8 out of 10, Wendy. Okay? No. It started pulling at 6 to 6, then ended at a deadlock at 4 no and 8 yes for manslaughter. That's what it is. So if you're seeing anybody say, oh, it was 8 to 10, no. It was, or 8 out of 10, it was 4 no, 8 yes. Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Chargers goes back to the jury verdict slip that was all confusing. People were confused about the verdict slip. How funny. She should have been acquitted. I agree. Yes, the remaining charges were that they were hung on and that instruction paper was confusing. So again, this is the intermediary, and this is the person who spoke to or contacted David Yannetti. This is based on what Juror C was saying to them, then passing the message along to the informant. Okay. Argument. The jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correction, or not of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about their jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. And then he's just quoting that. Again, Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such a crime. So they really want to stress that fact. Like, murder 2, you have to get murder 2 off the table. David Yannetti, reflecting text messages from Juror B, it was not guilty in second degree. No one thought she hit him on purpose or even thought she hit him on purpose. Reflecting Juror C, statement relayed by intermediary C that there was no consideration for murder 2. Miss Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a matter prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of the deliberations. Even assuming arguendo, and contrary to the foregoing, this court finds the retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. Re-prosecution is independently barred because there was no manifest necessity to declare mistrial and on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Miss Reed did not consent to the declaration of a mistrial because they're alleging like we didn't have a chance to object. You didn't give us a chance. You called in the jury too soon. Rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Absent the defendant's consent, state and federal double jeopardy prosecution's bar. As a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance of the defendant of being able once and for all to conclude confrontation. Excuse me, I am going to cough. Sorry about that. Whoa. So sorry about that, guys. Where was I? To conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, one, counsel must have been given full opportunity to be heard, and two, the trial judge must have given careful consideration to alternatives to a mistrial. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. So again, she was like, okay, they're on an impasse. Cool. Call in the jury. Nobody said anything. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. I don't know. I mean, they're citing all these different things. Like, we can look this up too. I don't know if what the legal ramifications are in Massachusetts, if it's up to the judge to be like, hey, like, does counsel object? I mean, Bev was pretty much on it the whole trial asking, does counsel object? Constantly checking in with at least with the Commonwealth, but I mean, constantly asking, do any of you guys object to this, that, or the third? So I don't I don't know if it's protocol for the judge to do that when she's reading off a verdict or declaring a mistrial before bringing the jury in. So if any of y'all know, let me know in the comments section. Appreciate it. Finding no manifest necessity, where the trial judge first ruled that he was going to declare a mistrial and then, almost as an afterthought, unenthusiastically asked whether counsel objected. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges charges on which it was deadlocked. Yeah, so like to poll the jury. Had the court done so and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. So remember, in the beginning of this video, I read that it seems, at least when there is a verdict, that it's up to the judge's discretion on whether they want to poll, the jury. That's my understanding of it. I don't know if that's the case, if it's the same with the mistrial. Indeed, with virtual ignominy, the cases have applied collateral estoppel to the bar the government from, wow, I can't even read that word, relitigating, I think that's how you say it, a question of fact that was determined in defendant's favor by a partial verdict. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury had reached an agreement. So in other words, if they were unanimously decided, we have a right to know what they decided on, and that should be read out loud. The Supreme Judicial Court's holding that courts should not request partial verdicts unless they're included offenses charged in a single count does not pertain here. As the Roth Court acknowledged, inquiry concerning partial verdicts, unless they're included offenses that have not been separately charged, carries a significant potential for coercion. So this is, again, going back to what Alan Jackson was saying, was it seems like you were trying to guide them to making this specific decision. Declining to require court to consider giving the jury new options for a verdict in the form of partial verdicts unless there are included offenses where, under Arkansas law, the jury's options were limited to two, either convict on one of the offenses or acquit on all. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return 3 separate verdicts on 3 separate counts. Distinguishing situation where a defendant has been charged in separate indictments or complaints, each with separate verdict slip. In this circumstance, where the jury reports a deadlock without specifying the count or counts on which it has reached an impasse, it is straightforward, and the defense contends constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. So again, this is them being like, well, we should at least be able to investigate. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended in this motion. So I want to stop there for a second because this came up in another live stream. I think Melanie Little's live stream from earlier today. Definitely go check her out. So again, this is in regards to the preferred method of whether counsel is able to initiate contact with the juror. So this is why they're filing this motion. The preferred method, and this again, I can link this in my description below if you want to read further, but if the lawyer wishes to initiate the communication with a juror or prospective juror after discharge of the jury, the lawyer must send notice of the lawyer's intent to initiate such contact to counsel for the opposing party or parties, or directly to the opposing party or parties if not represented by counsel, 5 business days before contacting any juror. So that's if they want to contact the juror. They did not contact the jurors. They are making it explicitly clear in their motion that they contacted us. But if we want to further communicate with them and contact them, we have to go through this. The notice must include a description of the proposed manner of contact and the substance of any proposed inquiry. And if you count it too, because they were contacted on that Tuesday, it would be 5 business days, right, from now? Just pull up my calendar, right? 1, 2, 3, 4. Okay. 5 business days before. Okay. So it makes sense. They're filing this motion now. And they're like, hey, we want to contact them. The notice must include a description of the proposed manner of contact and the substance of any proposed inquiry to the jurors, and where applicable, a copy of any letter or form written communication the lawyer intends to send. The preferred method of initiating contact with the juror is by written letter, and the letter must include a statement that the juror may decline any contact with the lawyer or terminate contact once initiated. So it's up to the juror. They're not forced to reciprocate the communication with the lawyer. If the lawyer seeks to initiate contact through an oral conversation, whether in person, by telephone, or otherwise, the lawyer is nonetheless required to provide opposing counsel, so the Commonwealth, or opposing parties with prior notice of the substance of the intended communication 5 business days before the contact is initiated. So they're 100% within that. This is Commonwealth versus Moore. I'll link this too. I'm not going to read through this, but this just goes more into why it is what it is. So there you have it. Just to give you some more context of that, because I didn't know how that worked. I'm sure my lawyer friends do. Should this court find that further factual development is required, the defense respectfully requests that the court conduct of voir dire, because we love voir dire days here in the Cameron case, of the jury and or an evidentiary hearing to substantiate the existence of an acquittal, should the court seek the affidavit of each juror, A, B, and C. The defendant asked for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty on counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be tried for a crime on which she was previously acquitted by a jury, and the defense submits that the post-verdict inquiry is equally warranted in the present context. Just as the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3, and do not invade the heartland of jury deliberations. Heartland is a really good show, by the way. I really like it. It's a good Canadian show, very wholesome. They just came out with a new season, sorry. But preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the double jeopardy clause and its related state judicial protections. All right, so conclusion. So now we're wrapping up on the motion, then we'll get into the affidavits. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court issue an order dismissing counts 1 and 3, respectfully submitted for the defendant, Karen Reed by her attorneys, David Yannetti, Alan Jackson, and then Martin G. Weinberg. And then they include this. Martin G. Weinberg do hereby certify on this day, yada, yada, yada. I guess this includes Snap. I didn't even realize. So I downloaded all this different stuff, but this includes everything. It's awesome. I think this includes Alan Jackson's too. So I don't even need to switch tabs. This is great. Cool. So we'll go through Yannetti's first then, and then we'll go through Jackson's. Okay, so again, this is the affidavit that is signed by David Yannetti, and I just why would he put his career on this and sign something if he didn't at least believe it to be true? They gotta shoot their shot. You miss 100% of the shots you don't take, right? That's that what it goes? Yeah, okay. Anyways, I'm delusional at this point. David Yannetti, I do hereby depose and state the following is true to the best of my knowledge and belief. I am an attorney licensed in Massachusetts since December 20th, 1989. My main office is this address. On January 29th, 2022, I was retained to represent the defendant, Karen Reed, regarding the above captioned matter. On July 3rd, 2024, now I'm sounding like Michael Morrissey, so please excuse me. On July 3rd, 2024, I received communications from 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and C, both of whom were part of the deliberating jury in this case. To my knowledge, Informant B and Informant C do not know each other. So again, he's trying to say they have not talked. The jurors obviously know each other. They have a group text, but the informants don't know each other, as far as he knows. On July 3, Informant B sent me a screenshot. So not Juror B, but Informant B. He or she had received from someone, hereinafter Intermediary B, because again, this is the friend of a friend, of text messages that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with that Hernandez, so the Tui Rodriguez, or I guess it's Hernandez in Massachusetts, thing to look at the other side, it turned into a bully match. So it got heated. So before that, it seems like everybody was like, all right, we agreed to disagree and we're cool and we're fine. And then when the judge was like, you guys need to come up with a decision, you need to come up with a verdict. You were the best people to do that. It was like, all right, game on. Everybody put their mean face on. I thought the prosecution didn't prove the case. So this is coming from Juror B to Intermediary B. No one thought she hit him on purpose or even thought she hit him on purpose. Whatever that means. They gave us free counseling forms when we left. So counseling forms, I guess some people are speculating that it's for therapy because that's something that happens sometimes when you're dealing with a really just emotional case like this. Which is good. I think that's good that the court provides that. Based upon the first name of Juror B given to me by Informant B, I believe I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. Okay. On July 3, Informant C contacted me. So now that was juror. So this is 2 days after. Okay. So mistrial was declared on July 1. 1 day later, a juror directly, not an informant, a juror contacted Jackson. July 3. This is when Yannetti. Yeah, this all happened on July 3. 2 people came to David Yannetti. Informant C contacted me to say that he or she personally knows Juror C, as they used to work together. Informant C and Juror C also have a mutual friend, hereinafter intermediary C, who is the current coworker and friend of Juror C. Informant C told me that he or she had posted something about the Karen Reed case on Facebook on Monday. I guess they're referring to the juror or the intermediary. I'm a little confused about that. On July 1, he or she told me that he or she believes that post led to intermediary C to okay, so juror C posted. Oh, no, I'm sorry. Informant C posted something. Got it. Intermediary C saw that post and hit them up. And asked, okay, and inform him or her that juror C was a deliberate. So then they were like, yo, remember so and so who you used to work with, who I'm biddies with now? Guess what they told me? That's how I'm reading it. Informant C told me that he or she thereafter reached out to juror C via text message and discussed his or her experience as a juror in very, very general terms. Okay, so then the informant reached out to them. They discussed what an exhausting experience it was, and that juror C was relieved it was finally over. Intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened. Okay, so it seems like informant C hit up their buddy juror C. Juror C was like, I don't really, want to talk. I'm just happy it's over. Happy it's over. This is what it was like to be a juror. It was probably their first time, and they're like, "Holy smokes, this was a doozy." And I don't blame them. it was a doozy for us at home too. But I can't even imagine being a juror on this one. So then intermediary C, who works with juror C, they're in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, informant C sent me 3 screenshots of a text message exchange she or he had with intermediary C. Informant C told me that intermediary C was reporting to him or her during this exchange what juror C had revealed during the Zoom meeting. The text message exchange reads as follows. So this was in the a part of it was in the motion. No consideration for murder too, so that's exactly what the other two said. Manslaughter started pulling at 6-6, then ended deadlock at 4-8 yes. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Remember, Bev stressed that. Only what was admitted into evidence. Ultimately, he or she voted no because the cause of death was twofold of hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. Wildly interesting. Wildly interesting. So it seems like they were deadlocked on one could have caused the other, but I assume that they thought, well, the hypothermia wasn't obviously caused by getting hit by a vehicle. But then I guess there were some people who were saying, well, he could have, maybe she did gently tap him and he hit his head. And I can only imagine what was going on in the jury room, right? We can only imagine. We can only speculate. Whole jury felt very intimate. This is so interesting. The whole jury felt very intimidated by Higgins' presence at the end. So if you remember, our friend, Paul O'Keefe. This is the only time I'm going to bring him up in this video again. Paul O'Keefe said in his interviews, and I'll link the videos below, where I talk about this, that he invited Brian Albert, Jen McCabe, Kerry Roberts, Colin Albert to closing arguments. Brian Higgins wasn't there. Brian Higgins was only there the day he testified with his lawyer, and then he He dipped, or the days. I don't remember if it was multiple days. I think it might have been 2 days. And then dipped. Never to be seen again. Haven't heard a peep from him. I mean, I'm sure his lawyer is like, "Please don't say anything. You've said enough." But that's wildly interesting. That the two of them, like, they can't even follow who's in this case. They can't even get the people in the story straight, which is kinda concerning because it just goes to show how hard it was to follow everything. I mean, with all the witnesses, like, was it Lally's intention to confuse the jury? I don't know. Throw all these witnesses in and just get them, like, all mixed up? I mean, I don't know. That's a little concerning. But also too, the fact that they're saying what we were all thinking online and speculating. They're confirming for us that they were intimidated by Brian Albert. And whether Paul O'Keefe did that, I mean, he said he did that on purpose. He said he did that on purpose. He invited them on purpose because he wanted them to know that we're not going to buy into this conspiracy that was created by the defense and that we stand by these people. That's why he invited them. I mean, and there's some funny. Let me see if I can bring it up because there are some funny people on Twitter. Like, people on Twitter are crazy, but people on Twitter are kind of funny too. Like, there's just so much funny stuff. Like, let's see if I can find it. That one. Oh my god! And there's so much stuff about like Jen McCabe, and I might be able to find it on Google. If I find a tweet later, you guys know what I'm talking about. Like, him just like, it's so awkward. And like Jen McCabe with the blank stare. Oh my god, this picture. Like, I don't like, this guy makes me feel so uncomfortable. Like, just imagine this guy staring at you from across the room and then like mouthing weird things. Like, he kept moving his mouth. I'll enlarge that. Look at that. Look at this guy. That's scary. That's not a guy I would feel safe about protecting me. He used to be Boston. I think he's retired now. And he's like a first responder. But that's freaking terrifying. I would feel intimidated too, but they can't even get the names of these people straight because it's confusing. I get mixed up all the time with the family tree. Like, with all the Alberts and who's related to who. I have to constantly look that up because it's just so it's hard to keep track of. There's no family tree, let alone the timeline of alleged events. Yeah, I'd be intimidated by this guy too. 100%. Like, is he gonna come after me and my family after that? If I choose the wrong answer, is my life going to be in danger? And I think it's amazing that the jurors who have come forward did the right thing and told the truth. And hopefully they do testify under oath and we can put this nonsense to rest. But that's just crazy. All right, let's continue. So she's not sure what she's going to do. She's going to lay low for a couple days and see where it takes him or her. Hasn't ruled out anything. Jurors all have a group text going. Interesting. If it was no consideration for murder too. Shouldn't she have been acquitted on that count? Yeah, I mean, if I was the informant, I'd be like, yeah, that doesn't make sense. And hung on the remaining charges. It goes back to the jury verdict slip. That was all confusing. She should have been acquitted. I agree. So again, this isn't a conversation directly with the juror. This is between the informant and the intermediary. She should have been acquitted. I agree. Yes, the remaining charges they were hung on, and that instruction paper was very confusing. What a great experience for him or her. Amazing that they let the Alberta in the last day. I don't know what that means. He or she felt very honored to be part of it. He or she was redacted physical description juror C. Okay. So probably expressing some kind of emotion. Everybody else was from a professional walk of life. Interesting. They all got along and never heated. They agreed to disagree and respected each other. Interesting. I wonder what their profession was. Was from a professional walk of life. So I wonder what they mean by that. If they mean, and we can only speculate, right? Like, sorry, I don't even have this blown up all the way. Yeah, we can only speculate what they mean by that. I mean, I heard rumors, I can't confirm this, but that there was a doctor, ex-law enforcement, which is very interesting. So I'd be curious what that means, professional walk of life. Like people who are kind of within this like area. I don't know. That's the way it should be. I knew it was an intelligent jury. They will be studying this case in law programs for years to come. I know not to investigate and try a case. If they all agreed on no for murder too, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried. So informant C is like, yo, this is effed, and somebody's gotta do something. If you're not, I will. Based upon the description of juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating jury, so not an alternate. Signed under the pains and penalties of perjury. Yeah. So he's signing an affidavit. Now this is Alan Jackson's. Alan Jackson, declare, I am a partner at the Los Angeles law firm of Worksman Jackson Quinn, LLP, and I have been licensed to practice law since 94. I guess he's a little younger than Yannetti. Huh. I am counsel for Karen Reed, appearing on her behalf in the Commonwealth of Massachusetts. On Tuesday, July 2, I was contacted by juror A, true name and identity withheld to maintain anonymity. Based on my conversation with juror A and that juror's description of who or she was, where he or she was seated, and contained identifying information, name/occupation, was disclosed during the voir dire process, I was able to positively identify which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Excuse me, I need to back from coughing. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. So remember, this actually happened in the Adelson case too, is that a juror or an alternate, I think, contacted Dan Roshbaum as well too, that they would have voted a not guilty verdict. So these things do happen. Juror A indicated that he or she believes it is important to disclose each result because he or she believes that those results significantly impact Miss Reed's rights. And that's amazing that people are freaking good people like that. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count one. So again, it's consistent with the other two said. Juror A was emphatic that count one, second-degree murder, was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count one, the jury also unanimously agreed that Karen Reed is not guilty of count three leaving the scene with injury or death. On July 1, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. So I might pull up that clip again, just so we can see. I'm going to read this first, but I'm going to go back and source that clip real quick for you guys. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing an opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. And then they went right into the, okay, so like, what's everybody's vacation plans? When can we meet and do this thing again? Neither Miss Reed nor counsel consented to the entry of the mistrial. Devil's advocate, they also didn't speak up and say anything, but I don't know. I don't know what the protocol is. I don't know what the protocol is in Massachusetts. It could be different. I don't know if they were waiting for her to say something, or if they have the ability to stand up and object. But I know it was quick. She was like, okay, I'm declaring a mistrial, get the jury. Like, but again, could Jackson have spoken up and said something? I don't know. Once the jury was seated, the court then read the jury note verbatim in open court without providing any opportunity. Yep. Neither Miss Reed nor her counsel consented. I read that. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. So I wonder what they mean by that. Like, if Bev, after the fact, they tried to say, hey, whoa, when the camera, I don't know, because I didn't see that on camera. I didn't see that. They just went right into scheduling. So I don't know if it was something that wasn't filmed, wasn't picked up, or if they're, I don't know. I didn't hear Bev explicitly say, like, no, you can't request what the split was. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse, and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and 3. Miss Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States and state of California and the Commonwealth of Massachusetts. And there's that. Okay. So let me, because like this, so I was thinking we could go through the jury instructions, but it's like an hour long, and it's just like listening to Bev read is just kind of painful, personally. But I can do a breakdown video if you guys want me to do that, where she's explaining the jury instructions and like whether they were clear and easy to understand. I know a bunch of lawyers, a lot of lawyer content creators on YouTube have covered it. Like Emily D. Baker has done a breakdown of it, so definitely go check out her. I can link out her video as well too. But judge declares mistrial. Yeah, I just want to see if I can pull this clip up. Oh, here we go. Boom. Okay. Just so you can kind of see how quick this transition is.
Judge Cannoni, despite our rigorous efforts.
So this is a note from the jurors after she read the Tui Rodriguez instruction.
We continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All right, sir.
I mean, that was that. But there was a clip before that where she tells the lawyers. Let me see. Let me see. Just want to make sure I find the right clip for you guys. But then we're gonna get back into Bev. I don't care what you have to say, Court TV. I should know better than freaking sharing Court TV stuff, right? Oh yeah, then that's the other thing. Everybody's saying, "Oh, this is all hearsay. This is hearsay about the split," and it's not necessarily hearsay. It's just it's emotion. It's emotion. Let's see what happens next. Can't really declare anything until we actually hear from the jurors themselves. For for yeah, these are all just like reaction clips. All right, it's fine. I'll see if I can find it at some point. I'll link it for you guys. But I definitely want to get to this other news. So, what do you think about the motions? The motions to dismiss counts 1 and 3. Do you think that? What do you think is going to happen next? Do you think that the court is going to? I mean, hear the defense? Are they going to have a separate evidentiary hearing? Are they going to have a voir dire and call in those jurors, call in all the jurors? I don't know. I don't know how that works. If they can call in, I mean, I imagine they can do whatever they want. They can call in back all the jurors and be like, hey, what was your verdict originally? Not now that you've been able to research the case and, see what the world is thinking about it and all of the additional evidence that wasn't able to be to come through. But what was your original verdict in the jury room? So let me know what you guys think. If you think this is a break for the defense, if you think it's going to go nowhere, if you do think it's all hearsay, and if you think it's hearsay, why do you think it's hearsay? Let me know. But now that we're talking about Judge Bev, right? Now that we're talking about Auntie Bev, as the internet likes to call her. So this motion was filed, right? But Busy Bev, she was busy. She was a busy bee today. List of County jurors impounded under new order from Judge. So Judge Beverly Cannoni's order, which is set to expire in 10 days if it's not extended here. So let's play this clip.
They reached a unanimous not guilty verdict on 2 of those charges. The second-degree murder and leaving the scene of a fatal crash. According to the defense, it's the third charge, manslaughter while operating a motor vehicle under the influence of liquor, that had the jury divided.
Also today, the lead investigator in the case, State Police Trooper Michael Proctor.
All right, we're going to get to him. Michael Proctor. I thought they were going to get more into into Bev's. But the judge who oversaw a Camry case on Monday, a week after declaring a mistrial, that the list of jurors who took part in the proceeding will be impounded, meaning out of public view, so they're not going to get doxxed. Making sure that they stay protected, even though a lot of people are like, it's so ironic that Bev is like concerned about protecting the identities of the jurors when you declare, you had it's been 7 days. Like, if you were that concerned, why didn't you put in the order the same day or the day after? You were too busy getting your toes in the sand and catching some sun, getting your tan on. I don't know if she has to wait a certain amount of time before she can file anything like that, but I mean, it seems really interesting when it's the same day the defense files a motion claiming that 3 people came forward, 1 directly from a juror and 2 from informants who had communicated or close ties to the juror, that have all said the same thing. Deadlocked on count 2, not guilty on count 1 and 3. So, interesting. Interesting timing. Norfolk Superior Court Judge Beverly Cannoni, said in her order that there is a risk of immediate and irreparable injury should the list be made available to the public at this time, and cited the widespread coverage of the murder case, which has reached far beyond Massachusetts, and ongoing commentary on social media. Read the order, which is set to expire in 10 days if it's not excited. I mean, in a way, I think it's good, because I feel like if the identities are released, and I don't know how true or not true this is, would their motion to dismiss me null and void? I don't know. I don't know. I mean, these people would definitely be faced with a lot of criticism online. There's a lot of people who are angry. Like, how can you be so blind and dumb and this, that, and the third? And I mean, there's no point in name calling, because again, we know more than the jury did. We have the internet. We could go back. We can dig deep into the past of these people's lives. Dig up the fact that Chris Albert was involved in a hit and run in the 90s and killed a foreign exchange student. We can dig into that. Or that Judge Bev is her brother defended Chris Albert, was his public defender for the hit and run case. These are all things that the jury didn't know, all things that we were able to know. So let's read this, and this is a lot shorter than the motions. Order of impoundment. The Supreme Judicial Court has recognized that the safety of jurors is crucial to the fair functioning of the judicial system, and that the justice system owes the highest degree of vigilance for their personal safety. This case has garnered significant and divisive attention in Massachusetts and across the nation and the world. Don't forget our friends overseas. The trial was live streamed on local and national broadcasting channels. The proceedings continue to be the daily subject of commentary on various social media platforms. People associated with the case have been charged with intimidation. Who are you talking about, Bev? Oh, I wonder, who are you talking about? We all know that you're talking about Turtleboy. We all know who you're talking about. Wow. If there was ever a shot that was fired, that was it. Wow. Okay. We're doing that. All right, Bev. All right. She's likely seen some of the articles that he's put out by her too, by the way. So I have no doubt about that. This court acknowledges that the names of impaneled jurors who rendered a verdict in a criminal case must be retained in the court file and made available to the public. The jury, in this case, did not render a verdict. However, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. So you think Turtleboy is going to go and intimidate? That's what this feels like. And it's interesting timing, because I think he has his hearing this week for his case. And it's funny, because when I first read through this, like, I just lightly skimmed through it. And I was like, Are you talking about Turtleboy? I'm like, no, there's no way, no. And then I looked online, and I wasn't the only one who thought that. And I'm like, all right, okay, we're doing this. We're actually doing this. And that just goes into my whole theory of, I don't think Bev is part of the cover up, but I definitely don't think that she likes Karen Reed. And I think she'll do whatever she wants and whatever it takes to make sure that everything is under her control. And like, this is her town. Like, I really feel like she feels ownership. This is her town. This is her court. This is her county. This is her state. Which is ridiculous because it's like Karen Reed is in Mansfield. I don't know how far that is from Dedham, but I just feel like there's so much like of that like like gross, overly proud of where you're from and ownership of just everything, of the court, of this whole like thing, and the way that you would talk to Jackson, like these flashy, and how the people who were in the opposition talk about Karen Reed's attorneys too. Meanwhile, it's like David Yannetti's a Boston kid. He's a Boston boy. And now she's calling shots at Turtleboy. I mean, it's what does that have to do with this case? I mean, not for nothing, he wasn't charged with jury intimidation. And if anybody was intimidating, who were they intimidated by? Brian Albert, who they mistaken for Brian Higgins, who showed up to court with his lawyer and paused during his testimony to bring up his lawyer. So if anybody's intimidating the jury, it's not the guy who is charged with witness intimidation falsely. It's the guy who was staring them down. Like some mafioso who was gonna go with his boys, Vinny and Jimmy, in the back and beat them over with the club over their head until they gave them the right verdict. That's who they were intimidated by. The people who weren't charged with any kind of intimidation, who weren't charged with the murder of John O'Keefe. I mean, what timing? And this just makes me feel like, are you part I don't think you're part of the cover up, but are you part of some weird like are you just do you want this trial to continue? Because based on your long size, by the way, side note, there is a Twitter account called Auntie Bev's Long Sigh. Highly recommend you give them a follow because it is hilarious. I digress. But according to your long sighs, it seems like you wanted nothing to do with this trial and you were over it. Unless your hatred for Karen Reed, just like all these other people who have this deep hatred for this woman they don't even know, just want to do everything that you can to make her life harder. Because that's what it feels like. And make Turtleboy's life harder. He's got nothing to do with it. Why? Wait, he's got nothing to do with the jury. He's got nothing to do with it. He's not allowed to report in the same way. You don't see people, Ted Daniel getting charged, or Julie Grant, or Christina Rex, or any of those reporters. You don't see any of them getting charged with allegations of potential jury intimidation. Are you kidding me? For being a reporter? And getting news quick? You know how many people in TMZ get leaked information all the time? Get called into the trial and they don't get charged with witness intimidation? Are you kidding me? Consequently, the court finds that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. The court further concludes that there is a risk of immediate and irreparable injury should the list be made available to the public at this time. Well, if you really thought that, Bev, you would have done this, 7 days ago? You would have done this. This order shall expire 10 days from the date of issuance unless otherwise ordered by the court for good cause shown pursuant to Rule 3B of the Uniform Rules of Impoundment Procedure. Dated today. So, there's that. There's that. What do you think of that? Auntie Bev coming in clutch for baby Lally. Crying, "Wah, mama. Help us. The big bad lawyers. They filed this motion. Help me, mama. Help me. Help me, Auntie Bev." And like, I'm not a huge fan of Bev. I didn't think she was, I don't know. I know people are going to disagree that she was extremely biased. I feel like there were definitely moments, more than one, definitely, that she was definitely favoring prosecution. But then there were moments, particularly during Proctor's testimony, where she was kind of more, I don't know, not leaning towards the defense, but I think we all shared that mutual disgust. And I was like, all right, maybe she's playing fair. Maybe she's finally just taking her job seriously. And I don't know what the heck that's about. I really don't. But we're not going to talk about Bev anymore. We're going to talk about speaking of Trooper Proctor, we're going to talk about this man, this clown. And then we're going to wrap things up. Trooper Michael Proctor, lead investigator in Karen Reed, suspended without pay. So there was some justice. I mean, it was a big day for the defense. I definitely, like, in the beginning of this video, I meant it. It was a big day. A busy Monday on all accounts. Everybody was doing things. Massachusetts State Police Board on Monday recommended that Trooper Proctor, the disgraced lead investigator in the Karen Reed murder case, be suspended without pay amid an ongoing internal affairs investigation into his unprofessional behavior following the death of Boston police officer John O'Keefe. Interim, Massachusetts State Police, Colonel Maughan, so remember he had his statement, I think I posted in one of my last videos, accepted the 3-person board's recommendation following a duty status hearing in Framingham, making Proctor's suspension effective immediately. Dozens of people gathered outside the Massachusetts State Police Barracks in South Boston Monday, celebrating the news that State Trooper Michael Proctor was just suspended without pay, because why should you guys have to pay for that schmuck? For this freaking doofus. Your hard-earned money, pay for him. I think he was making like something like his salary was like $154 or something a year, 154,000. Let's see, Michael Proctor. I had a whole link up. How much? State Comptroller. Okay, so this is according to the Herald, and I can't pull it out because they're gonna hit me with a ton of ads and block everything. But earned $184,397 last year. I mean, that's absolutely insane. Absolutely insane. It was a step in the right direction, but it's nowhere close to the finish line, said Paul Cristoforo, a Karen Reed supporter. Today was just the icing on the cake, but it will be best when he's actually fired as an employee of the state. Yeah. I mean, I think he should be run out of town. He should be deduced to, I wouldn't even say garbage duty, because I think those guys make pretty decent money. But he should be reduced to, like, I don't know. I don't even know. Like, you're not even worth, like, any job. Like, bagging groceries. Bagging groceries at the Stop and Shop. That's what you should be reduced to. Since you love using Stop and Shop bags, you and your freaking team. You and your team of elite investigators. You should be bagging groceries at freaking Stop and Shop. Juan relieved Proctor of his duties. So, that was the other day. The other day, meaning last week. In the 2-month-long murder trial due to a deadlocked jury, blah, 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 which we know. Peter Allican. He's like one of the only sound minds who actually speaks on court TV. Like, the only sound of reason. They wouldn't have done that unless they really thought he did something egregious. Yeah. Boom, boom, boom. We all know that. After the initial affairs investigation, the department says it might pursue charges against Proctor that would be adjudicated by state police trial board. Interesting. So yeah, I guess this is the report. Let me see. Download. Let's see. Am I showing? Stop share. Just pull it up for you. Probably not gonna read the whole thing. My wife just knocked on the door and was like, "All right, it's time to eat." So temporary. Oh, cool. Yep. Yeah. So maybe we'll get into this in a separate video because it's a little lengthy, but this goes into like all the disciplines and stuff. Really interesting. Interesting stuff. Yeah. I'll link to that in my description though, so you guys can read through it. But this is the reaction that they were talking about in the article from Karen Reed fans. So is his wife. Yeah, people are not a fan of Lizzie Proctor. People are not a fan of Lizzie Proctor. So there you have it. It's a good day. Justice does prevail in the sense of Proctor, schmucks like Proctor lose their everything. Hopefully more. You know, I predict. I mean, I'm not gonna speculate any rumors of what I said this once on Twitter, but like, you know, I'm not gonna talk about his wife or anything like that. But I just have a feeling all things are going downhill for Mr. Proctor and Mrs. Proctor, and you know, we'll see what happens. We'll see what the aftermath is. Hopefully, he never gets to work as a state employee ever again. Hopefully, he gets, who knows, run downtown or deduced to Stop and Shop bags, you know, stocking up your groceries at Stop and Shop. Or even that, I feel like even that's too nice. Like probably like the local like food store that like nobody goes to, like that. Or maybe working at 7-Eleven, you know, like as a bag boy or something. Or like he can't even like interact with customer. Like he has to stock shelves or like do inventory in the back. I don't know, but that's all the news I have for you guys today. Let me know what your thoughts, feelings are about just all of this, the emotions. I know this was like a very heavy, long video. I appreciate you all watching until the end and just helping me navigate. I know my nose has been like in and out, and I kept coughing, so I apologize for that. Hopefully tomorrow I'll be better for our video, and who knows what kind of news we're gonna have tomorrow. Hopefully we'll start being able to dig a little bit into the Sandra Bertramore case. If there's other cases that you want me to dig into, please email me again at alexasroommate@gmail.com. That's ALEXASROOMATE@gmail.com. So again, that's one M. And if you want to make a donation, so I just set up a couple of ways you can continue to support the channel. Absolutely no obligation on your end too. Just the more that we grow and reach a broader audience, the more I want to give back to this community, and I want to bring on the kind of guests that you guys want to see on this channel, experts. And I deeply believe that time is valuable, and I want to be able to support those people and bring people on and be able to compensate them properly for their time. So any donation you want to make is greatly appreciated. I have those links in my description below as well. You can donate via Cash App, as well as through Stripe directly, or through the Buy Me a Coffee link as well too. Or if you feel more comfortable donating directly to the Karen Reed Defense Fund, you can do that as well. Or if you can't make a donation, no worries at all. Just get the word out, share this video, give this video a like, because any any little action that you take is helpful. It helps small channels like mine reach more people, shows the YouTube algorithm that this news is important, which is the main goal here. But if you do decide to make a donation directly to me, I will take 20% of every donation at the end of every day, tally it up, take that 20% and donate it directly into the Karen Reed Defense Fund or any case fund you and this community believes in. You know, I'm planning on doing like monthly polls. There's a lot of stuff that I'm thinking about cooking as this continues to grow, this community. But nevertheless, I'm incredibly grateful to have each and every one of you. Here's to 200 more subscribers, and I will see you in the next video.